Statutory Supervisors bill may sound very dry to many members of the general public. Helpfully, I record a short conversation I had with my senior partner on the similar subject years ago while practicing law in Auckland. He asked me to either explain difficult issues by showing graphs or telling stories. A story by Sunday Star Times newspaper published on 28th November 2008 was right to the point. Lending role questions for New Zealand Guardian Trust and Hanover Finance was the headline. Guardian Trust provided more of property development. Its main funder at that time was Bridgecorp. Guardian then provided additional finance with the first mortgage, which meant it ranked ahead of Bridgecorp's loan in the event of a default. When Bridgecorp went, using the language of the newspaper, belly up a year before, Hanover stepped in and took over its mortgage on the development, making it the second mortgage on the land secured by Guardian's mortgage. This put Guardian in an unusual position because it also acted as corporate trustee for Hanover and had a supervisory role over that company's affairs. The story went on to say that Hanover was forced to exercise mortgagee sale and Guardian was forced to follow suit. Both companies were in default of their obligations to investors and both suspended repayments to their investors. Hanover then tried to put together a restructuring plan, and the plan must first be approved by Guardian in its role as Hanover's corporate trustee. Guardian insisted there was no conflict of interest in its roles as trustee and mortgagee, citing Chinese walls within the company. That is to say that the firm had developed or implemented policies and procedures to safeguard insider information and to ensure that no improper trading occurred. There is no need for us to follow up the story, which was nearly 2 years old, but the story explains well why the law is being changed. Mr. Speaker, in its regulatory impact statement on this bill, the Government Department says it supports the proposed legislation except for the requirements for trustees to report breaches in trust deeds in real time and for the Commission to have the power to direct the trustees to take a particular course of action to remedy breaches. The Government Department fears that the power to direct a trustee how to act will blur the clarity between trustees and the Securities Commission, and it says it does not fit well with the proposal to give the regulator the ability to take legal action against trustees, which would likely be exercised at the same time. So the requirements for trustees to inform the regulator of breaches in real time could lead to significant compliance costs that are likely to be borne by firms seeking to raise capital. The other aspect, or the elephant in the room, which this bill ignores is, according to Chapman Tripp, is the dynamic created by the changing nature of the trustee and issuer relationship. That is, the trustee as frontline regulator is in the unusual and potentially having to negotiate its regulatory mandate and its remuneration with the very party it is charged with regulating, namely the issuer. Another article I wish to quote is from the website depositrates.co.nz, which was published on the 4th of March 2010, and read, Commerce Minister Simon Power included trustees in his review of the Securities Act after a report by Companies Registrar Neville Harris in March 2009 slammed finance companies for acting like Ponzi scheme and raised concerns about trustee diligence and accountability. Interestingly, that article attracted a comment which was posted on the following day, and I quote, From the past experiences we have all just very recently witnessed, would you really support trustee companies continuing with any power whatsoever to oversee finance/investment companies? Where have these trustee companies been when the investors have needed them the most? Whilst the Securities Commission have appeared to be near useless, I feel they are the lesser incompetent of the two. Get real, take note how the Australian Securities Commission works. They aren't pen pushers with wet paper towels to beat you with. End quote. The name of the commentator is Craig. The family name is not available. So this bill, borrowing the words of Chapman Tripp again, reflects both regulation and deregulation at the same time. On one hand, trustees and supervisors will need to be licensed and comply with ongoing requirements, namely the regulation. But on the other, the preferred position existing trustees enjoy will be removed, opening the way for others to enter the market, i.e. the deregulation. According to McDowell Stewart New Zealand Finance Companies Report 2008, New Zealand's financial system is worth $431 billion, of which registered banks is worth $345 billion, non-bank financial institutions $22 billion, savings institutions $4 billion, and managed funds $60 billion. So I'm very pleased to rise to support this bill in its first reading because the bill purports to protect the interests of investors and enhance investor confidence in financial market through various measures. The law has to be changed because New Zealand places too much reliance on private supervisors and because, as evidenced by those real-time stories, they're not accountable enough. Other problems with our regime were raised by the string of finance company collapses, including the lack of independence and capability of some trustees. Labour government made great progress in tidying up the financial services sector, including the review of financial products and providers, and I am very pleased to see that this bill, which is a continuation of those efforts, is now being progressed. However, this is a complex, technical, and very important bill, and we will be keenly involved in scrutinizing it at the Commerce Committee. However, as Madam Chair Honourable Leon Dazelle, who spoke earlier in the House, pointed out, the time frame and the way the bill has been presented may be hampering submission efforts from stakeholders, professionals, and the general public, and the extent the bill is to be scrutinized. Thank you very much.